Hi, good evening. My name is Larry Chatou, and I am a member of the USC Gould Alumni Association's Washington, D.C. committee. I'm also a 2003 graduate of the USC Gould School of Law. I am incredibly pleased to welcome you tonight to Constitutionalizing Our Democratic Expectations with Vice Dean Franita Tolson. As many of you know, Franita Tolson is Vice Dean for Faculty and Academic Affairs and Professor of Law at USC. A nationally recognized expert in election law, Vice Dean Tolson has been very busy of late. Believe me when I tell you she is double booked all the time. She's testified before the House Judiciary Committee regarding the reauthorization of the Voting Rights Act. She's also authored a legal analysis for an amendment to the US Constitution introduced by Senator Warren and Senator Durbin that would explicitly protect the right to vote. In addition, she's an election law analyst for CNN and co-hosts an election-themed podcast, Free and Fair with Franita and Foley. Her forthcoming book, in Congress We Trust, Enforcing Voting Rights from the Founding to the Jim Crow Era, will be published in 2021 by Cambridge University Press. Now, I would like to turn things over to Dean Andrew Guzman. Dean?
Welcome, everybody. It's terrific to see you all here. And I'm delighted that we're doing this tonight. I want to first thank a few people. I want to thank Nicole Stark and the entire Development and Alumni Relations Office for putting this together. I also want to thank our events team who do a lot of these things. And one of the great luxuries we have at Gould is that our events are always seamless and flawlessly put on. So I'm appreciative to them. We're obviously doing this virtually. I don't want to skip over the fact that it would be so much nicer to gather in person and to see you all face to face. Until we can do that safely, though, I'm really pleased we can do it here. I also want to acknowledge that we are at the start of Black History Month. We normally would be putting on a brunch with our Black alumni at this time of year. We obviously can't do that. But this event, I hope, is also attractive, and I'm really glad we're able to do this event. And the fact that we're doing this virtually on this platform has allowed us to open it up and extend the invitation to participate to a wider USC Gould community, which is also one of the a terrific benefit to what is otherwise an unfortunate reality. So let me switch to the topic of tonight. I'm sure I don't have to tell anybody here that our democratic norms face a set of unprecedented challenges, and the success of our democracy is something we talk about a lot more than we did just a few years ago. I also don't think I need to tell anybody here that the right place to have a conversation about that reality is a law school. We operate at the center of these questions, and the ways in which our nation can or should respond to the challenges of the moment are, is the bread and butter of our existence and our scholarship and our teaching and our advocacy. And so I'm really delighted that we have here to lead the conversation one of Gould's most terrific scholars, a nationally recognized expert in voting rights and constitutional law, and Vice Dean for Faculty Affairs, which means all the faculty have to do what she says. Vice Dean and Professor Franita Tolson, I will leave it to you. Take it away.
Okay, thank you so much, Dean Guzman. I am very happy to be here, and thank you so much to Nicole Stark and her team for putting this event together. Just as a warning before I get started, if a little face appears to either my left or my right, don't fret, it's just a kid. But I welcome the opportunity to talk about something I've been thinking about since really the beginning of the Trump administration, but definitely towards the last days, where we saw a time in which the administration was really, the environment, it was punctuated by lies and spurious legal challenges and ultimately violence in a way that we hadn't really encountered before in recent decades. And so in some ways, this raises significant questions about the legitimacy of our political system, right? These are core democratic issues. And in particular, this system in which lies can take hold and fuel the possibility that because of the Electoral College, there can be an outcome to a presidential election so at odds with the will of the people. The fact that this undemocratic outcome was possible highlights the crisis of legitimacy that has always haunted the American democratic experiment. Contrary to popular thought, this isn't technically new to us, right? There's always this sense that of impending doom with respect to our democracy and our elections. And part of the reason is that it's not only the Electoral College. So the Electoral College, as you know, enables the loser of the popular vote to nonetheless become president, which is something that we have all lived through. But the Supreme Court has also told us in a case called Rucho versus Common Cause that some level of partisan gerrymandering in drawing congressional districts is okay, even if it distorts the will of the people. And in either case, they're not going to police it anyway, right? To the victor goes the spoils. And of course, each state gets 2 senators, regardless if the state's population is 4 million or 40 million. Some would say that this is illegitimate in terms of democratic norms. And while on some level, we have to accept that the Electoral College can alter election outcomes. So it happened in 2016, but it also happened 4 other times in our history where the popular vote winner lost the Electoral College. But I think the recent attempted coup revealed an additional flaw, right? So the lesson to some extent is that our system is so distorted and so messed up that had both houses of Congress been in one party hands, then we could have ended up with a very different president today, right? This is a much more ominous proposition than a candidate losing the Electoral College vote because he or she did not get enough votes in key states. Now, we can speculate on all of the reasons why such an outcome would be illegitimate or inconsistent with our democratic expectations, but I think we will find that expectations are all that have been keeping our democracy afloat. As the presidential election reveals, there are far too many flashpoints where something can go wrong, right? So you have Article 2's delegation to state legislatures to choose the electors. You have the meeting of the electors to vote in December, right? You have Congress's obligation under Article 1 to count the votes. You have the vice president's role to oversee the count, right? So there are just simply too many actors with key roles and who have partisan intent, frankly, for one to be able to say that the Constitution dictates a particular process outside of this basic framework. There are simply too many outcome determinative questions that crop up during this process that we don't conclusively know the answer to. So, for example, can state legislatures allocate their electors differently following an election, especially in a situation where they disagree with the outcome of the vote, right? So this will make the vote of the people advisory rather than binding. What's the answer to that question? Does Congress's role in overseeing the count allow it to determine competing slates of electors in contravention of the wishes of the state legislature who might prefer a different slate, right? What is the answer to that question? Can the vice president refuse to open a certificate from a slate of electors that he deems to be illegitimate, he or she deems to be illegitimate? Undoubtedly, these questions, depending on how we answer them, raise the prospect of some pretty illegitimate outcomes. But I wonder if it is because some of the answers to these questions do not align with our expectations, as opposed to being prohibited outright with the Constitution. In addition, the fact that people are rightly surprised by just how undemocratic our system is, this in itself tells a bigger story about the state of our democracy. The story is that we, the American people, have failed to properly constitutionalize how we see ourselves as a participatory democracy, even if that's the standard by which we judge the legitimacy of our government. To some extent, democratic legitimacy requires that we constitutionalize our expectations for how government should operate, because norms and practices are not always going to be enough. Now, this is not to say that our norms are never enough to guide us. After all, we have been guided by democratic principles for over 2 centuries, and the norms are often important for supplementing the constitutional text. There has been both constitutional and extra-constitutional progress in expanding the electorate, even if the progress doesn't perfectly align with our expectations. Frankly, it never will, right? We often want more than our politics can give us at any given time. Nonetheless, it turns out that memorializing our democratic expectations in the constitutional text is still pretty important, particularly when the Constitution uses words like Republican government, and also the Constitution enshrines protections for the right to vote, right, which says something about how we view ourselves as a democracy. The problem is that we as a society have often failed to live up to what these notions entail at various points in our history. There are times where we have failed the norm of Republican government. Well, we haven't sufficiently protected the right to vote. So this raises the risk of failing to constitutionalize our democratic expectations or exactly how we see ourselves as a democracy. This is the risk. As the baseline for what counts as legitimate government shifts away from the bare minimum that the Constitution requires, political norms play an increasingly important role as we further depart from this baseline. If we get too far away from the constitutional text and we use political norms and expectations to fill in the blanks, then it turns out that it is only these norms rather than law that forces political actors to respect our democracy. Over the past 200 years, we have had a mixed record in navigating this gap between the constitutional text on one hand and our democratic norms and expectations on the other. But we have usually averted disaster through a mix of constitutional amendment, the democratization of our political culture over time, and electing political leaders willing to adhere to our norm. If anything, the recent election and recent controversies have taught us just how important that latter thing is. But the reality is that the prospect of disaster, of things going completely left, is always present when democracy operates in this manner. To make this point, let me start with what should be an obvious example to show you how these factors have operated in our democracy, right? This give and take between the constitutional text and our democratic norms and expectations. So if representatives up for election in 2020 were elected from states that had electorates identical to those of the 13 states in 1789, I think everyone would agree that it would hardly be a recipe for legitimate government of any sorts by today's standards, right? We could not have electorates that mirrored those that existed in 1789, right? So the disenfranchisement of African Americans, the disenfranchisement of women, propertyless white men would deprive these states and their representatives on the national stage of any claim to legitimacy. And this is because there have been a number of events that have transpired since that era, including, for example, the expansion of the electorates in the states, really as early as the 1790s beyond property white men. This was done through state law. There have also been shifting norms around voting and participation that coincided with the rise of mass political parties over the course of the 19th century. And of course, we can't forget that we've had constitutional amendments that were enacted to enfranchise various groups over the course of 2 centuries, right? So we are a very different electorate than we were 200 years ago. So there have been changes in both our law and our norms about what legitimate government, or to use constitutional nomenclature, Republican government requires. While these governments might have been legitimate by 1789 standards, we the people have redefined the majoritarianism, underlying the Republican guarantee to embrace democratic ideals. And in the process, we have reset the baseline for what constitutes legitimate government, right? It's 2021, we are a diverse electorate. It is not 1789 where we are an electorate of property white men. But let's be clear, having an electorate that consists almost entirely of white men would not only violate the constitutional text, including the guarantee clause, which guarantees a Republican form of government, as well as the 14th and 15th Amendments, it is also not within our collective understanding of a legitimate electorate independent of that constitutional text. So it's not just text that defines us. Our norms and our understandings matter as well, right? Most people, including political elites, would say that electorate consisting almost entirely of white men is so far outside of our norms as not to be a legitimate state of affairs by any measure. Now, we don't necessarily need further constitutional amendment to make this expectation more concrete, right? The expectation that our electorate is diverse beyond just simply white men. Although recent events have made me start to question this assumption, and I'll come back to this point later. But let me give you another example, one that is just as extreme in my view, but might not be as clear, right? It's an example in which we have not fully thought about the consequence of the gap between expectations and constitutional text. So I argue that the failure to constitutionalize our democratic norms also helps explain why African Americans were disenfranchised in the South for decades following Reconstruction. The constitutional text fell far short of what was needed to make African American enfranchisement permanent. And Congress tried to make up some of this gap by statute, but it didn't work, right? We needed a stronger constitutional text in order to make those expectations permanent. So between 1868 and 1870, Congress passed Reconstruction Acts readmitting the former Confederate states into the Union and imposing conditions on that readmission. Notably, these conditions, which, as I mentioned, were imposed by statute and not constitutional text, specifically had to do with voting rights. So, to give you an example, the 1868 Reconstruction Act readmitted North Carolina, South Carolina, Louisiana, Georgia, Alabama, and Florida provided in relevant part, quote, the constitutions of neither of said states shall ever be so amended or changed as to deprive any citizen or class of citizens of the United States of the right to vote in said state, who are entitled to vote by the Constitution thereof herein recognized, except as a punishment for such crimes as are felonies at common law, whereof they shall have been duly convicted under laws equally applicable to all the inhabitants of said state. Right, so these were known as the Reconstruction Acts, and these are the acts that enabled the former Confederate states to rejoin the Union. Now, these acts, which were enacted over the course of really a 2 to 3 year period, but mostly from 1868 to 1870, were important for a number of reasons. First, they clarified the requirements of Republican government, right, as detailed by, as I mentioned before, the Guarantee Clause, which guarantees to every state in the Union a Republican government. But also importantly, these acts help clarify the scope of the 14th Amendment, which was ratified in 1868, and also the 15th Amendment, which was ratified in 1870. The Guarantee Clause, for its part, legitimized much of the Reconstruction program, especially as Congress brought the Southern states under federal control to facilitate the creation of new, more inclusive post-war governments. The Military Reconstruction Act of 1867 put the former Confederacy into federal receivership. So this gave Congress the authority to create these new governments, to force these states to adopt new state constitutions, and also force these states to have electorates that were racially diverse. And so in the process, this updated our standard for Republican government, right? Republican government could no longer be a government solely governed by white people. So essentially, you had these very racially diverse governments elected by a much broader swath of we the people than at any other time in our history. And the Reconstruction Acts, by readmitting these racially diverse governments, not only set this new baseline for republicanism, but also provided guidelines for what was required in order for these governments to stay Republican. So, for example, the Act's prohibition on amending state constitutions to disenfranchise people who were then qualified to vote under state law reinforced both the Republican guarantee and the 15th Amendment's prohibition on racial discrimination in voting. Because keep in mind, these new state governments enfranchise Black men for purposes of participating in state constitutional conventions and voting in state elections. But the Act went even further than that, right? They also clarified the scope of Section 2 of the 14th Amendment. Now, Section 2, which allowed Congress to reduce a state's delegation in the House if the state abridged or denied the right to vote, contained language that exempted those who committed a felony from the penalty of reduced representation. Don't feel scared if you never heard of Section 2, right? It's never been enforced. But in essence, it's a really powerful political tool for Congress to use against states that try to disenfranchise their citizens. But it does have an exemption. If a citizen has committed a certain type of felony, then the state will not suffer the penalty of reduced representation. So in essence, states could disenfranchise those who have committed crimes without suffering the penalty. But the Reconstruction Acts are really important because they clarified the scope of Section 2, right? The Reconstruction Act stated that individuals could only be disenfranchised for felonies at common law. So not any felony, right? Not any crime that the state has deemed qualifies for disenfranchisement, only felonies at common law. Now, a felony at common law was pretty much a serious crime, right? Many of them were punishable by death. The non-common law felonies, to provide greater context for this, were murder, robbery, manslaughter, rape, sodomy, larceny, arson, mayhem, and burglary, right? So it's very clear from the Reconstruction Acts that the world of felonies that the framers of the 14th Amendment believed would exempt states from the penalty was very, very small. And I do think that even further, the Reconstruction Acts directly raised the question of how can we have constitutional text and statutory guidance that sheds light on the meaning of that text, all of which, mind you, points in the direction of broad enfranchisement. Yet we currently live in a society in which there are both artificial barriers to voting that have a racially disproportionate impact, as well as an extensive felon disenfranchisement regime across most states, right? Many states disenfranchised for hundreds of crimes rather than the common law felonies that the acts identified as appropriate for disenfranchisement. And an answer for why this is the case is because political actors have been able to exploit the gap between the constitutional text, i.e., the Guarantee Clause and the 14th and 15th Amendments, and the more lofty democratic expectations of those who framed the text, but who tried to better capture their expectations through the Reconstruction Acts or by statute. And in fact, it is this exploitation that led to the darkest period in American history, known as redemption. In 1890, Mississippi was the first state to call a convention to amend its constitution and alter its voter qualifications in the wake of Reconstruction. And the entire point of this was to disenfranchise African Americans despite the 14th and 15th Amendments. And they accomplished this in a number of ways. So first, the state introduced a very onerous residency rule. So the rule required that voters live in the state for 2 years and be registered for 4 months before the next election. So compare that to most states today where you simply have to reside for 30 days max, but in other states it's significantly less. So you have to live in the state for 2 years in Mississippi in 1890. The Constitution, the state constitution also imposed a literacy test, which was quite effective at disenfranchising individuals because it required potential voters to read a provision of the state constitution at a time where there was high illiteracy rates. And one way that the state constitution avoided disenfranchising white people was that it grandfathered in those individuals whose grandfathers had been registered to vote. Now, keep in mind, African Americans didn't officially get the vote until 1870 with the ratification of the 15th Amendment. So this grandfather clause effectively exempted white people, but not Black people, from the literacy test. The state constitution also instituted a poll tax of $2, right? So this was in conjunction with the residency requirement and the literacy test, really successful in disenfranchising African Americans in most of Mississippi's counties. Historically, a poll tax was a tax paid as a precondition to voting. And in essence, it was one of the most effective voting mechanisms ever devised in terms of disenfranchising people. Mississippi was quite successful in its efforts. The changes in its state constitution cut African American turnout from 30% in the 1888 presidential race to virtually nothing thereafter. So it pretty much wiped out the ability of African Americans to vote in the state wholesale. And it served as a model for other states across the South it was a blueprint of sorts for how to disenfranchise without running afoul of the 14th and 15th Amendments. Because importantly, many of these changes were legal at the time, right? This is the aspect of this that is often overlooked. It wasn't that Mississippi and its state constitution was explicitly racially discriminatory. All of this was written in facially race neutral language, right? So the reason that it was so effective in disenfranchising African Americans is that Mississippi relied on the discretion of election registrars to apply the rules strictly to African Americans while making exceptions for white people. And this is the same enforcement discretion that would pervade the criminal justice system. So African Americans were, during this period and from then on, disproportionately arrested and convicted for crimes that triggered disenfranchisement. So many states, including Mississippi, expanded their universe of crimes to include crimes that they believed that African Americans were most likely to commit, including crimes like vagrancy, crimes of moral turpitude, notably, though, crimes that are not really common law felonies as required by the Reconstruction Acts, right? So crimes that went well beyond the very narrow category of crimes envisioned by those acts. And these actions were validated by the court system. So the US Supreme Court, in a case called Williams versus Mississippi, reviewed the changes to the Mississippi Constitution. And they reasoned that there was no judicial remedy for the discrimination because it was facially race neutral, right? So it wasn't something that was captured by the Reconstruction Amendments or prohibited by them. In other words, despite the racial purpose behind the 1890 changes to the Mississippi State Constitution, and also despite its discriminatory effect, remember, it was incredibly effective. The court held that there was no 15th Amendment violation because the text itself was race neutral. Another case that's of note is a case from the Mississippi Supreme Court. So in 1896, that court upheld the state's felon disenfranchisement law despite its racially discriminatory purpose, because it was not a violation of the 15th Amendment for the state to target, quote, certain peculiarities of habit, of temperament, and of character that tended to define African Americans rather than whites, right? So facially race neutral, we don't care about how it's enforced. Now, of course, these laws would violate the 15th Amendment as it is currently interpreted, right? Because they were adopted with discriminatory purpose. But in the 1890s, the courts did not conceptualize intent and or effect as raising significant constitutional issues, effectively allowing states to bypass the expectations of those who ratified the Reconstruction Amendments, their expectation in particular that they were creating more egalitarian and inclusive political regimes across the South. Likewise, the poll tax was also legal in the 1890s, right? The tax would not be barred for federal elections until 1964, and it would not be struck down as applied to state elections until the Supreme Court's decision in Harper versus State Board of Elections, where the court found that the poll tax violated the 14th Amendment. But prior to these changes, states like Georgia took advantage of this gap between the constitutional text and the expectations of the framers of that text, and using the poll tax to disenfranchise African Americans. In the 1890s, Georgia adopted one of the most restrictive poll taxes in the country. And it was restrictive because it was cumulative indefinitely, meaning the failure to pay in year one meant that you owe year one and year two, and so on. And it just continued to accumulate until it was paid. But keep in mind, there's no record of anyone ever being prosecuted for failing to pay a poll tax, because most states actually went out of their way to avoid collecting it, right? They did not want to collect it from voters who they deemed to be politically or racially undesirable. And the tax today may not sound expensive. It was between $1 and $2. But keep in mind how much people made in the late 19th century, right? So in the former Confederate South, the per capita income in 1880 was $86 per year. And in 1900, it was $100 per year. So most people couldn't afford to spend $1 to $2 to cast a ballot. But let me give you a sense of the impact of this. I'm going to share my screen. Okay, so as you see on the screen, you have a chart that gives an overall sense of the impact of the Georgia poll tax. So on the left-hand side, it just shows the rates for Georgia versus the rest of the South. Georgia already had pretty low voter turnout as compared to the rest of the Southern states. So from 1880 to 1888, it dropped from 48% to 37%, even though the rest of the South held pretty steady. But what's really telling is when you break it down by race. So in Georgia in 1880, it was 56% turnout among whites, which held steady over the course of the decade. Still lower than neighboring Florida, right? 80%, and it actually increased to 84% for whites by 1888. But look at African American turnout, right? In 1880, already terrible, right? 39% of African Americans were voting in Georgia. By 1888, this had dropped 20 points. Florida, of course, saw a drop as well because there were increasing efforts to restrict voting among African Americans across the South. But Florida really had nothing on Georgia. Georgia had become quite adept at keeping African Americans away from the polls, and this is reflected in the numbers across over the course of the 1880s. Keep in mind, the law itself was race neutral, right? So facially race neutral, this all came down to disparities with respect to enforcement. Nonetheless, it's clear, right, that the laws of Georgia, just like those in Mississippi, operated contrary to the expectations of those who wrote the Reconstruction Acts and the Reconstruction Amendments, right? Technically, you can imagine an argument that came later that the poll tax was contrary to a democracy and also expectations for exercising the ballot. But it turns out that trying to do this by statute, particularly statutes that are widely considered unenforceable today, as the Reconstruction Acts are, it was insufficient to memorialize the understanding of those who enacted the 14th and 15th Amendments regarding what Republican government required, even if we now have a sense that the poll tax is inconsistent with that ideal. Southern states were quite effective at bypassing these expectations. they adopted these race neutral laws with respect to voting, with respect to the criminal justice system, even though they nominally comply with the Reconstruction Amendments. It's pretty clear that the 15th Amendment will prohibit a law that is facially race discriminatory, right? That's contrary to the text, and that's also contrary to Supreme Court precedent coming out of the 1880s. But instead of going down that road, they opted to do the facially race neutral route, and then just enforce them in a racially discriminatory fashion. Now, to our credit, right, we have been able to address this gap between text and expectations in subsequent decades, right? This is no longer the world that we live in. In the 1960s, we achieved this through the Voting Rights Acts, Supreme Court precedents protecting the right to vote, as well as constitutional amendments that, as mentioned, barred the poll tax, but also enfranchise those that live in DC, enfranchise those who were over 18 years of age, and not to mention the 19th Amendment, which came some decades earlier, right? So, but clearly there's this marriage between constitutional and statutory fixes to create the electorate envisioned by first the Reconstruction Amendments and later the Reconstruction Acts, but it took, 7 or 8 decades. And unfortunately, there's still a gap, right? There's a gap that can be exploited despite this progress. And there will always come a time where we have to reckon with the fact that our progress has not gone far enough, fast enough. It has not gone far enough in making our expectations permanent. Let's circle back to felon disenfranchisement to make this point, right? So take Richardson versus Ramirez. Richardson versus Ramirez was decided in 1974 after the end of the Civil Rights era. The Supreme Court held that states that disenfranchise those who commit felonies do not violate the Equal Protection Clause, right? So consistent with our earlier conversation about Section 2 of the 14th Amendment, right? Remember, Section 2 expressly exempts disenfranchisement grounded on prior conviction of a felony. And so the court looks at that language and they use it to interpret the scope of Section 1 of the 14th Amendment, even though Section 2 had never been enforced. Now, Richardson versus Ramirez is still good law, but it is nonetheless inconsistent with the broad principle of enfranchisement embodied by Section 2's text. And in fact, Section 2's textual exemption from the penalty of reduced representation is only part of the story. And this is yet another instance of using sort of norms and expectations to supplement the text. So to give you just a little bit of historical background, representatives from Missouri, which was a border state during the Civil War, lobbied for the exclusion in Section 2, where the state would not suffer the penalty of reduced representation for disenfranchising those who commit a felony, because a significant portion of its population were ex-Confederates. So if Missouri, which was a loyal state during the Civil War, had been, if Missouri disenfranchised these individuals, they would then be subject to the penalty of reduced representation. So they would lose congressional representation despite remaining loyal to the Union. So, it goes without saying that one can be disenfranchised for treason, which actually is the only crime that's defined in the Constitution. The Reconstruction Act sought to further memorialize this understanding that disenfranchisement should only be for a narrow category of felonies by focusing on felonies at common law. Yet lower courts have cited Richardson for the proposition that Section 2 is an express grant of authority for states to disenfranchise those who have committed felonies. But get this, it's pretty much any felony, any crime that the state defines as a felony, and sometimes it extends to misdemeanors, right? We are so far away from the Reconstruction Act's focus on a very narrow category of crimes. And to be clear, this gap between the text and our expectations has significant implications for our political system today. Take a look at these next slides. So if you think about the implications of, and really legacy of Ramirez, and also a century of using a criminal justice system to subjugate and later disenfranchise African Americans, the legacy of this is very much still with us. So this table shows disenfranchised African Americans with felony convictions from 2016. So if you look, I tried to circle states with the highest rates of disenfranchisement. You'll notice the trend. So there are quite a few southern states, but also a number of western states. So Alabama disenfranchises 15% of African Americans, Arizona 11%, Florida 21%, Kentucky 26%, Mississippi 15%, Nevada, 11%, Tennessee, 21%, Virginia, 21%. So it's not a coincidence that there are a lot of Southern states here that disenfranchise large portions of their African-American population to this day, right? This is a legacy of this gap between sort of the framing of the 14th Amendment and how the framers expected that text to operate. And this just shows it's very important for us to close this gap, right? The history, if anything, indicates that the failure to constitutionalize or really update our democratic expectations as they are reflected in the constitutional text, particularly when there is a disconnect between we the people's view of how government should work and the bare minimum that the Constitution requires. We have to update it or else we'll be subject to backsliding, right? It's very easy to lose the democratic norms that have held sway when we don't make them permanent. So to give you an example, the Constitution might prohibit discrimination on the basis of race, but ask yourself this: does it prohibit race-neutral practices that have the effect of discriminating on the basis of race? 50 years ago, we had updated our jurisprudence, our statutes, and our text to answer this question in the affirmative. I would point to the 15th Amendment and the Voting Rights Act as proof that it does reach race-neutral practices. The Constitution does reach it, right? I would also look to Supreme Court cases like Harper, which I mentioned earlier, and also the one-person, one-vote cases decided under the 14th Amendment to corroborate my view that the Constitution prohibits these practices. But now I'm not so sure, right? I will have to consider the lineup of the Supreme Court, the ages of the justices, where the law professoriate is. Gosh, will the DOJ even enforce the Voting Rights Act? I would query whether other portions of the Voting Rights Act are constitutional, given that the court struck down part of the Voting Rights Act in 2013. And I would think about a host of other factors before I even attempt to answer this question that was so clear only a short time ago. Our current crisis of legitimacy only reinforces this point, right? Our politics are such where political elites are questioning the presidential election because Black and Brown people voted in a way that they simply didn't like, right? 50 years ago, we would have condemned this in clear terms. Now, senators and representatives claim that they are being responsive to their constituencies by questioning the election. It is this fact that is causing me to second guess my assumption that we don't have to update our text to make permanent the expectation that democracy is not a mostly white, mostly affluent affair. The truth is that some states have been successful in passing restrictive voting measures in an attempt to keep the electorate mostly white and mostly affluent. And they have been able to do so in part because we've constitutionalized a prohibition on racial discrimination in voting, but we have not explicitly constitutionalized our expectation that the right to vote should be available to all those legally entitled to vote without artificial barriers that make exercising that right illusory. We don't have an explicit constitutional right to vote in the text, which would close much of the gap between the text and our expectations. Instead, what we have is scholars like me who play with the language of the Constitution in an attempt to make our expectations permanent, right? I do it in my writing, arguing that the implicit right to vote in the document should be read broadly, trying to flesh out the assumptions about voting that underlie the text. The court has done it as well, right? So I'm in good company, right? Harper versus Virginia State Board of Elections is not a case that's based on any explicit constitutional text, right? It's our implicit understanding that equal protection protects a right for everyone to vote on equal terms. But the problem is that when we don't make our expectations, our assumptions explicit, then we can lose ground like we have in the 7 years since the Shelby County versus Holder decision in which the Supreme Court struck down part of the Voting Rights Act. As it stands, the Constitution is a framework and the details are in the politics and the social movements and the wars and the bloodshed and the sacrifices, all the things that we the people have given in order to create the democratic norms that are currently under threat. But as long as this is so, right, where the details are contingent based on expectations and norms, then we will always be at risk because the only standard of legitimacy that is permanent is the one that is constitutionalized in the text. Thank you. I'll take your questions.
So Dean, that was that was sobering. I didn't realize it was going to be such a sobering and
I'm sorry.
No, but I always like ending on hope, and I know you're gonna take us and make us feel hopeful by the end of this conversation. So I think we're teeing up questions right now. I've got just a ton of questions for you, and I would kick it off. I'll kick it off with a two-part question. But first, as you said, we've witnessed moments in our country's history where there have been swift and harsh backlash, to Black people flexing their economic or electoral rights. Tulsa and civil rights movement immediately come to mind. And I suspect and fear that we may be on the cusp of, I think you describe it as a second redemption based on how this last election played out. As you know, we have multiple instances where majority minority cities of one party determine the electoral outcome, in states where the legislatures are controlled by the other party. And of course, it's occurred because, of Stacey Abrams in Georgia and countless other unsung Stacey Abrams in other states. And for example, you focus so much on Georgia, right? And I think what's again shocking is that you talked about what happened 100 years ago, 50 years ago, but just this week, Republican state senators in Georgia introduced 8 bills which expand the ability to vote. No, I'm kidding. Of course, I'm kidding, right?
Right.
It does the exact opposite, right? It seeks to further restrict opportunities to vote. And so my two-part question is, what do you expect? I mean, do you expect similar responses in other state legislatures? First part, and then two, let's talk about solutions. So are there bills pending, before Congress that you think have a chance to address, so many of the problems that you just brought up?
So thank you, Larry, so much for those questions because I think they're important. Let me stay sober and then I'll try to offer some optimism. So in the wake of the presidential election, Georgia will not be alone in trying to make access to the ballot more restrictive. I think you'll see a number of Republican-led states that try to reduce opportunities to vote absentee, and also introduce probably new restrictions in order to make it more difficult to vote. Because, the fact that Georgia went blue this presidential cycle was quite the surprise. And so you have to wonder if other states that are kind of at that tipping point will try to get ahead of what seems to be an electorate that's trending in a more progressive liberal direction. And so I wouldn't be surprised if you see a number of states, in addition to Georgia, introduce new bills to restrict access to voting. So that's the first thing. But I do think that there's some optimism. So the optimism comes on the federal side. The federal government is considering a number of bills that would make voting easier. So one of the bills is H.R. 1, which is a pretty extensive change to our system of federal elections. So it would enfranchise those with felony convictions for purposes of voting in federal elections. It would require independent commissions to draw congressional districts. It changes certain aspects of our campaign finance system. It makes it easier to register to vote. It has online voter registration and automatic voter registration as well. So the bill does a number of things that make it easier and more accessible for people to vote, which I think will counteract some of the attempts in states to make it more difficult for people to vote. Another bill that's currently being considered is H.R. 4. H.R. 4 is the John Lewis Voting Rights Bill, which would reauthorize the preclearance provisions of the Voting Rights Act that were struck down by the court in Shelby County, which I referenced in my talk in 2013. So the preclearance provisions were the provisions that required certain jurisdictions, mostly the former Confederacy, but also some jurisdictions out west and I think a couple counties in New York, and North Carolina was partially covered, and so on. It required those jurisdictions to pre-clear any changes to their voting laws with the federal government before those changes could go into effect. So that was struck down by the Supreme Court, and there's a bill currently pending that will reauthorize it's a much more narrow version of that, right? Because it's trying to be responsive to the concerns raised by the court. So it would apply to fewer states. But I do think it will go a long way towards trying to counteract some of the trend that is emerging in the wake of the presidential election to make it more difficult for individuals to vote.
Got it. Thank you.
So optimism.
All right, so let's end on hope. Keep hope alive. All right, so we've got our first question from the audience. So it seems that there are three controlling factors for elections: Constitution, statute, federal and state, and norms experience. It's difficult to imagine a constitutional amendment to enfranchise people anytime soon. Norms and conventions were ignored or came close to being ignored in this election. Might the best solution be a model elections code propounded by Congress and or the bar? Doing so would shift the burden to the states to explain why they chose not to enact the basic model code. The disenfranchisement is a political act, and state legislatures need to be pressured to enact reasonable laws on polling places, mail-in ballots, counting procedures, etc. Why not call the bluff of those who want to review election policies and try to push for a reasonable rules of general applicability?
That is a terrific question. And I've kind of thought about ways to pressure states to be more inclusive, but you always run into this question of what requires it. And I think we saw a little bit of that in COVID, where um, voting rights advocates wanted states to make it easier to vote, because of the pandemic. They wanted to make it easier for people to cast a ballot. But you run into a wall because it's like, well, what requires a state to do that? Right? If a state has broad discretion over setting voter qualification standards and the conditions under which voting is exercised, it becomes very difficult to require states to take additional steps to protect the right to vote than the Constitution requires. So with respect to a model code, that would essentially be the same thing, right? It would be our plea to the states to adopt the model code, and we would need some penalty to apply to states who refuse to adopt it. Now, the American Law Institute already does a little bit of this, right? So there's a election law section where they try to come up with best practices for states. And there's also a lot of scholarship around this, things that election administrators should do in order to make sure elections run seamlessly. But I think it's a tougher question when we try to mandate that states take certain steps, because the Supreme Court, unfortunately, is very deferential to state power in this area. And the court is reluctant to force states to take steps beyond what the Constitution requires. And that's why this gap between our expectations and the text becomes important, right? Because if the COVID pandemic revealed that we needed states to do more, but we had a difficult time forcing them to do more in response to the pandemic, some states. Now, some were proactive, right? So this isn't, I don't want to proceed as if this is a 50-state problem. It's not. But there were definitely states where the state legislatures were unresponsive to the fact that we were living in a pandemic. Pennsylvania was one of them, right? Which is why Pennsylvania sort of became ground zero in the days after the presidential election, because of the state legislature's refusal to take steps that would have made counting the ballots easier in the wake of the election. It would have made things run quicker and more smoothly. And we wouldn't have had that, 4-day gap where the lies and the conspiracy theories can fester. And so, it's always important to keep in mind that we can have best practices, but requiring or mandating states to take those best practices is always difficult.
Thank you. So I have to tell you, based on these questions that are coming in, we should have made this a 2-hour panel, not just an hour. All right, so next audience question. Are there efforts that went into effect that during this recent election that helped with the felony conviction restrictions?
We tried. Amendment 4 in Florida got a lot of attention this election cycle because Florida voters voted, over 60% of them voted to change the Florida Constitution to enfranchise a large segment of those who had felony convictions. But then the state legislature came in behind that effort and required payment of all fines and fees prior to those individuals being able to register to vote. So whereas the prediction initially was that somewhere north of 1 million people would be enfranchised by Amendment 4, it turns out, I think something like 30,000 people were able to register to vote for the November election, in part because there was just a lot of confusion around whether or not they owed fine and fees. There was no centralized database. Florida has 67 different counties, many of which are not computerized, believe it or not, in this day and age. So there was no sort of place where they could go to find out if they owed fines and fees. It wasn't until 2 months before the election that Neil Sakatme, who is a professor at Georgetown, actually put together a website for individuals to be able to go to find out if they owed fines and fees. And he did that using whatever publicly available data that he could find. And I'm always appalled by this idea that a private individual had to do something that the state itself should have done, especially if the state was going to try to restrict voting in this way. So there are efforts at trying to re-enfranchise this population. HR 1, as I mentioned, is another sort of effort at the national level. But the response is always swift. Imagine the conversation we would have been having about Florida in the wake of the election had Amendment 4 actually lived up to its promise. We would have had a completely different conversation, right? And it just infuriates me because in reality, we don't really know who the voters would choose had these artificial barriers not been put into place. And so there are efforts, and I think if anything, the lesson of this most recent presidential cycle is that we have to be prepared for efforts to push back against those efforts as the midterms come up in 2022, because I think it'll just get worse instead of getting better.
And just a follow-up question comment on that. I specifically remember watching that play out in Florida. Was it Bloomberg who stepped in to pay some of those fees, right? And it raises the question of, what's the role of, corporations, the private sector, to sort of help counter some of these moves by the states.
Right. LeBron James paid, Bloomberg paid. It was a number of people who stepped up, but it's really sad in a system that sort of prides itself on being a democracy that third parties have to step up in order to carry out the obligations that states have unnecessarily imposed on people. Because keep in mind, one of the points I made in my talk about the Reconstruction Acts, why I think they're so important, is because when we talk about disenfranchising people for felonies, it's only supposed to be for a narrow category of felonies. Florida has over 500 different crimes that they categorize as a felony, right? At common law, there were only 9, right? So, which is crazy when you think about sort of how Florida has been able to exploit this gap in our constitutional text. And mostly it's because the framers of the 14th Amendment thought that the Reconstruction Acts were sufficient to sort of indicate to the world what their expectations were for that text. And it just simply turned out not to be the case.
Got it. Great. Let's see. So many questions, so little time. All right, let me skip down here. So another question. Are you explicitly arguing for a voting rights amendment to the Constitution? Do you have a specific text of the amendment in mind? And is that politically feasible? I think we all know the answer to the last question. So maybe you can focus on the other two.
Oh, yes, I am. There's a proposal on the table already that would create an affirmative right to vote in the Constitution, right? So no more trying to infer from provisions that talk about voting in the negative an affirmative right to vote. You have text that explicitly grants a right to vote. And also the proposed amendment would enfranchise those who have felony convictions. So it also eliminates the amendment for re-enfranchisement problems that we had in the wake of the presidential election. So yes, political feasibility is difficult, right? Because the threshold for passing a constitutional amendment, there are far more state legislatures controlled by Republicans unlikely to vote for this type of amendment than there are Democratic controlled legislatures. And so even if it makes it out of Congress, it's unlikely that there are a sufficient number of states that would get behind this. But I do think it's still important for having a conversation. To some extent, the Supreme Court has laid the framework for this, and we just haven't been holding the court to the case law that it has produced over the last 5 decades. In Harper versus Virginia State Board of Elections, the Supreme Court said that the Constitution already protected an affirmative right to vote, right? And so I think a document of a proposed constitutional amendment now does provide a way of thinking through what the right to vote that's inferred by the Supreme Court should look like. We don't do that anymore. We have let the court, at least initially, say there's a right to vote, and then pull back from that to the point where they're just almost absolutely deferring to the states, right? So it's really important that we have this conversation about what we expect the right to vote to. Let me put it more pointedly. What obligations do states owe to their voters in extending the franchise? As opposed to thinking about this in terms of what restrictions, as opposed to thinking about it in terms of whether or not we're infringing on state sovereignty when we tell states that they can't do certain things with respect to the right to vote. When we ask the question in that way, it makes it easy for the court to say, states have broad authority and can pretty much do whatever they want. In fact, they can pass a voter ID law even if they don't have any evidence of voter fraud, right? But if we've changed the question to, well, what obligations do states owe to their citizens with respect to the right to vote? Then you make it a different answer, right? In order to infringe on the right to vote in this way, to make it more difficult for people to vote, a state has to show evidence of voter fraud before they pass a voter ID law, right? The second question invites the analysis in a completely different way. And I think if we had an affirmative right to vote, we would get in the habit of thinking about voting that way. But arguably, by having a conversation, it invites us to revisit the implied right to vote that the court has already inferred from the Constitution.
Got it. So I think we may have time for one more question,
Okay.
and I will toss out one of mine. So
Okay.
so I'm currently in the middle of reading the New York Times bestseller, The Color of Law by Richard Rothstein, a groundbreaking investigation into how federal, state, and local governments during the mid-20th century deliberately imposed racial segregation on metro areas across the country. I highly recommend that once people are done with your book, they should go out and read this book. So one of the unintended or perhaps intended results of this is a history of national racial segregation. It's an exacerbation of gerrymandering. And so could you please discuss the impact of gerrymandering on the electoral process, why it's leading to more partisanship in Congress, and growing efforts to undo gerrymandering?
Well, the first thing is, okay, great. The important thing to understand is gerrymandering has always been with us, but I do think that it's important to understand that in times of high partisanship, gerrymandering can be especially corrosive to democratic norms. And the fact that you did have segregation, where you have Black and brown populations concentrated in urban centers, and you have white people more spread out, that means that rural white people tend to have more power than the urban cities, and gerrymandering just exacerbates that. And so when people are gerrymandered into safe districts, all they have to worry about is being primary. And in fact, if you look at the political conversation over the last 4 years, you have Republicans more concerned about being primary than any prospect of a Democratic challenger. That's a very real concern for them because of gerrymandering. But it also makes it less likely for them to reach across the aisle or be bipartisan, right? Because they only have to worry about a challenge from the right. They don't have to worry about a challenge from the left. So in fact, gerrymandering makes it very, very difficult to govern. And it's something that we really need to do something about. And so this is why I like HR 1, because it will bring in independent commissions to draw congressional districts with the hopes of possibly alleviating some of this partisanship that has festered in when state legislatures draw the lines themselves. And so I am, with a Democratic Congress, I'm optimistic that HR 1 will become law, but even there's still some political obstacles that stand in the way of that dream being realized.
Right, and I think just on that follow-up point, I think that's not necessarily a Republican Democrat issue, right? Because I think there are some Democrats that are in defense of gerrymandering.
Oh yeah, because the foxes are guarding the hen houses, right? So one of the interesting things about the Supreme Court cases, and I think the court was intentional about this, they took both Republican and Democratic gerrymanders, right? Like it's partisan in a sense that Republicans, if they're faced with a competitive election, there's a good chance that they would lose a significant amount of seats. This is why you see a push for more voting restrictions, right? They realize that it's not really a national coalition anymore. That's not a partisan statement. That's an empirical statement. It's not really a national coalition anymore. But Democrats can also gerrymander in ways that are corrosive to democracy. The gerrymander out of Maryland, that was not a good thing. That was bad. It really doesn't matter which party does it. It really is something that is offensive to democracy, especially if we hold ourselves out as one.
So as I said, clearly we needed another hour to keep this conversation going, but we are out of time right now. Dean, thank you so much. And again, on behalf of the USC Gould Alumni Association, thank you for joining us tonight. You have been absolutely phenomenal. Gave us, and again, ended with hope. All right, so that's what I wanted. So and again, we hope that you'll stay tuned for news of upcoming events this spring. So good night, everyone.
All right, thank you so much. Thanks for coming.